No, what I was trying to refer to is this. Clause 2 of Article 370 refers to a decision. It uses the expression decision. The proviso to Clause 3 uses the expression recommendation. But the commonality between Clause 2 of Article 370 and the proviso to 370(3) is some decision or action on the part of the Constituent Assembly. Just give me a minute. Both require some action on the part of the Constituent Assembly. Clause 2 requires a decision and the proviso to Clause 3 requires the recommendation. Now, according to you, once the Constituent Assembly completed its task in 1957, there was no question thereafter of invoking the proviso to Clause 3, because then it's worked itself out and the substantive part of Clause 3 and Article 370 becomes a permanent feature of the Constitution. That's the submission. It's a submission worthy of consideration. Absolutely, we have to deal with the submission. I'm just trying to explore that submission. There is one internal inconsistency in accepting that submission, because if that submission is right, qua the proviso to Clause 3, then the consequence would be that once the Constituent Assembly completed its task in 1957, there could be no amendment to the Constitution at all under Clause 2 of Article 370, which is belied not merely by constitutional practice, but the acceptance by both the state of Jammu and Kashmir and the government of India that amendments were being made to the Constitution even after 1957 and until the disputed amendment of 2019.
Just see sub-article 2.
Yes.
If the concurrence of government of state referred to in para 2 of subclause D of clause 1 or second proviso to subclause D of that clause be given before the Constituent Assembly is convened, it's purely limited.
It shall be placed before the Constitution.
Before. So, Lord, this is temporary within temporary. It is in respect of a situation where the Constitution now, a state has just come in, India is now become a republic, Constituent Assembly is going to be convened soon, and if some decisions are taken to protect them, that government may do anything it wants to, state government. It may give its concurrence and its consultation, but it should be very clear whether people want it. So they said, if you have done it before, then place it before the Constitution.
But then would the power of the state government to grant its concurrence under the second proviso to Clause D continue to operate once the Constituent Assembly completed its task in 1957?
What has happened is that government also has said in their affidavit, and
or would that power be exhausted once the Constituent...
All provisions of the Constitution, they have applied all provisions of Constitution by 1954. So really speaking, there is nothing left to be done. It is fully in operation now. 370 is fully in operation.
But then that is exactly.
We are talking about...
You're right, absolutely, logically. But then how do we explain the fact that there were subsequent amendments to the Constitution by the constituent orders?
What?
Because, the provisos to Clause D refer to state government. Clause 2 refers to the Constituent Assembly. And Clause 2 says if the consent of the government was taken before the Constituent Assembly was formed, you have to place it before the Constituent Assembly.
But a wrong practice cannot result in rewriting
we are talking of
provision.
We are talking of a practice over what? Over 46 plus 18, 64 years.
64 years, after 64 years, you can repeal it. But with great respect, the same argument, it means that 373 can't be repealed, and you continue with the practice. It's nobody's case.
That's completely out. But otherwise, you will have to say...
But it is not petitioner's case that no longer amendments of Constitution can apply. That's not petitioner's case. Question is, what is it that was not supposed to have been agreed, a promise?
If the power under the proviso to Clause 3 has exhausted itself, then equally the power under the two provisos to Clause D has also exhausted itself. In which case, how do we explain the exercise of that power for 64 years?
Looking at 373 independently of 371. 372 has no application now. It lived its purpose. Because by its language, it says that if any decision was consultation or concurrence was given before we came into existence, you please come back to us and our decision will be final. That's ended now. So 372 is dead. That's how they wanted it, constitutional framers.
371 survived.
Life to it. Likewise, 373 was also given in a limited sense, and we can't give now life to it. 371 would survive for the purpose of continuing. Your lordships are right. I am not for a moment suggesting conceding on that position. But if it has continued as a practice, there is nothing wrong about continuing that practice. That means that Article 370 is alive to the extent of sub-Article 1. No difficulty about it. Question is, can you repeal it? Can you withdraw it? Do you have power under 3?
But if 370 bracket 1 continues, it will be very difficult to say that 370 bracket 3 ceases to exist. Yeah. The modality for exercise of the power under 370 bracket 3 is a different issue, which both Mr. Sibal and Mr. Subramaniam and Dr. Dhawan have addressed themselves to. But it would be, because there has to be a logical consistency between how you interpret clause 2 and its impact on clause 1 and the proviso to clause 3. It has to be in tandem. Either everything remains together or everything perishes together.
Then let everything perish together.
But if it did perish, what about the fact that it was applied from 1958 to 2018?
Power.
And there's no power to any of the COs.
What is our submission? My submission is that if you wanted to do it, you do it by constitutional amendment. You have no power. This is a relationship which has been continued for a long time, since 1947. And 371, therefore, continues. Your lordships are right that time and again, Government of India, President has exercised powers and applied various provisions of laws and constitution from time to time. That's how they wanted it. That's how they wanted it. But, it's one thing to continue 371 and it's another to repeal 373. That's the difficulty. Nobody is not saying that presidential orders extending constitution are wrong or presidential order applying various laws are wrong. People of Jammu and Kashmir want Constitution of India. They want the laws to be applied. So, that position, there is nothing wrong about it. But if you repeal it, then that limited power of the state to say that certain laws should be applied in certain manner, that special status, that's the limited sense. So this is futuristic exercise of power by the president from time to time. Likewise, in D, such other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modification as president may by order specify. So power of president is not a surviving power to be exercised from time to time. That is why the words notwithstanding anything contained in the constitution are important in the opening of the article. Now just turn to Mr. Iyengar's broad statement. Please turn to PDF volume. Why not?
Whether under the second proviso, all the provisions of the constitution could not have been made applicable with the concurrence of the government.
Yes.
So is it not possible that if there is a concurrence of the government under D, the entire provisions of the constitution could be made applicable to Jammu and Kashmir?
There could have been. Except 370 can't be.
Except 370.
Yes, 373 is something which is left to the will of the people. There is no difficulty. Government says
then what remains if everything under the constitution can be made applicable by exercising the powers under D?
No, it needs consultation and concurrence.
That's what if with the concurrence of the question that is being put.
No difficulty. It can be undoubtedly. But the power of removing Article 370 is disappeared.
Is a different power.
That's an independent power. And government union in its affidavit has stated that all provisions of articles of the constitution have been made applicable to Jammu and Kashmir. And they have said that there is no difficulty on that. It has worked very well. They say so. There is no doubt that 370 has worked beautifully since 1947. This relationship. There has been no difficulty. It's not Government of India's case that there were impediments in running the administration of the state for any reason. Except national security and some violence, they have not given any other reason also. So this has worked, it must continue to work. Telling the learned law clerk that they are so lucky that they get opportunity to work with your lordships. When we started practice, each one of us, we didn't have that facility. We all learned on our own.
We are equally fortunate to have their assistants. They are very talented.
The quality of assistance they give, especially matters of this nature,
yes,
it's a Herculean task just to marshal the records, and they assisted tremendously in this.
No, in fact, I had to work hard to get my intern in court today. I wrote a very personal letter to the assistant registrar and said, please, for God's sake, allow them to come in. Because their assistance is amazing, and their experience, the memories they carry back home are unbelievable. This generation of students are outstanding, these lawyers. They are far more better than my generation was. Now see next para. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India. But the bogey is today in the country a wrong narrative that Jammu and Kashmir is not part of India because of 370. That's not so. As Jawaharlal Nehru also refuted when K.M. Shah said that yes, plebiscite. He said nothing doing. It's part and parcel of India. It's integral part of India. Today's House has no moral or constitutional authority to undo this just because it has a majority. For the people of Jammu and Kashmir, this was the essential feature of the Constitution. And we said, why forget this? We could bring Jammu and Kashmir into our fold. In fact, during this assembly debate, Maulana Hassan said, you are discriminating in favor of Jammu and Kashmir. Because Baroda Maharaja, and I come from Baroda, I didn't know this story at all, but it is mentioned here. Baroda Maharaja also didn't want to join the union. I didn't know that. And he was physically brought from England and forced to sign. So Maulana Hassan says in this debate that you have forced Baroda Maharaja to sign it. He didn't want to sign it.
Sayaji Rao.
Sayaji Rao. I was shocked to read because Sayaji Rao is perhaps the greatest of the rulers of 20th century. I don't know whether your lordships knows or not, but the man was absolutely unbelievable. I have been telling family to have a biopic on him. Because he was the one who sent Dr. Ambedkar for education. He was the one who always took guidance from Maharishi Aurobindo, who stayed in Baroda for many years. And some of the greatest people. Girl child education he made compulsory in 1920s. Girl child education, free and compulsory. And I was telling Dr. Dhawan in the morning that I saw a law against water pollution which was drafted in 1920s. So the man had a vision which was the University of Baroda, if your lordships have seen, so beautifully designed on Oxford Cambridge lines. So and a Maharaja would not take a penny more than what was decided for him by his Diwan at the beginning of the year. That you have to only spend this much for your personal expense, he won't touch a penny after that.
In fact, 1178, see that one para which says, now you will recall.
Yes, it's because it was not a transitional governments.
So therefore, the concurrence of the government also, in terms of the first proviso to clause D, was still the Constituent Assembly was convened and took a decision under clause 2. So even Mr. Iyengar construed it in a way that this concurrence was only up to that point when the Constituent Assembly would come into being. And what he says, that they will give that in the interim periods till the Constituent Assembly is formed, after which that power is exhausted itself.
Text of clause 2, just see in the context of 1.
So in which case, really speaking, there's no question of concurrence by the state government after 1957.
No.
But yet we operated that provision.
Please see that on C and D. What your lordships read was in part 2. Because the government was an interim government. So whether that government was rightly giving rightly giving advice or concurring, so they said let people decide to that limited extent.